Well, welcome back to another Cordell and Cordell Town Hall. I'm Scott Trout, CEO and Managing Partner of Cordell and Cordell. And as always, every month we bring this to you, as well as our podcast. If you haven't tuned in or subscribed to our podcast, which we do twice each week, you can do that, for example, on Apple iTunes. You subscribe, you'll be notified every time we drop one. We'll do 10 to 15 minutes of topics that are relevant to you for things and issues before, during, and after divorce. So today, as we do every month, we have a panel of Cordell and Cordell attorneys to join you, but always keep in mind that it is not legal advice. It is simply educational, informational. We cannot give legal advice in this virtual town hall. We're going to give you some experiences and some general overviews of the area of family law, and particularly the topic today, which is, can I modify child support or spousal support? It is a hot topic as we roll in and out of COVID and the kind of the roller coaster ride we're experiencing in the economy, whether we have unemployment or inflation. This is a really relevant topic. So we're going to get to our panelists here and introduce them in just a moment. But keep in mind, as we present to you today, in the second half of our virtual town hall, there'll be an opportunity for you to ask a question and get answers live from our panel of Cordell and Cordell attorneys. So you can do that right now. You can start submitting your questions in the Q&A section, and you can do that. Just give us your first name and your state. And if we have a member in your state, we'll make sure we can assign that question to them. But just go ahead and give those questions right now. We'll start accumulating them. We've got some that are rolling in, and we'll make sure we get to those in around the second half of the virtual town hall today. And they can be on any topic, obviously, in family law, not just devoted to the modification of child support or spousal support. So before we get to the topic today, let's go ahead and introduce our panel of attorneys that we have. Joining us in Chattanooga, we have Kellan Potts. Welcome, Kellan.
Hi, Scott. Thanks for having me on here. As you mentioned, I'm located in Chattanooga, Tennessee. I've been practicing a little over 5 years now, and I'm happy to answer any questions you might have if you want to submit them. Like Scott said, we'll see what we can do to get through this and help y'all get some information about modifying support and alimony and things of that nature.
Thanks, Kellan. Moving on, in Houston, Texas, we have Mysti. Welcome, Mysti.
Thank you, Scott. Yes, as you mentioned, I'm down in Houston, Texas. I have actually been practicing just over 21 years. I'm board certified in family law down here, and we have a great team of attorneys in the Houston area. So if you are in this area and you have any questions, please schedule a consultation. We'd love to help you.
Thanks, Mysti. And rounding out the panel for today, up in the Cleveland area, Robert Vizmeg. Welcome, Robert.
Hey, Scott. Nice to see you again. Like Scott indicated, I'm from Cleveland, Ohio. I've been practicing around 15 years, and candidly, I'm struggling with the expectations of Cleveland Browns' success. So I'm a little nervous for the season, but ready to talk to you all today.
I think I would join you, as well as probably the entire nation joins you in the being hesitant about the Browns this season, but looking forward to a full season. It'll be fun. So let's get right to it. Have some questions rolling in. Appreciate it. Keep going on the Q&A section. Again, we're going to get to them. The more questions you have, we'll start our lightning round earlier, just so we can get through them and all of them. We have around 7 or so questions already submitted, so we'll get to those. But before we get started on modifying your child support or spousal support, whatever it may be, let's take a very quick, brief commercial break. We'll be right back.
For many men, divorce brings a bewildering sense of loss. After years of commitment and responsibility, you find yourself alone, like you're the only person in the world. But you don't have to walk through this alone. We can help. For more than 30 years, Cordell and Cordell has guided men through the challenges of divorce. You're not alone. Call Cordell and Cordell, a partner men can count on.
All right, welcome back. So child support, spousal support, it is one of the key questions, whether you have both or either. Spousal support seems to always come into play with longer term marriages, and obviously around the country, there are different ways to calculate it. There are some states like here in Missouri that there is no calculation. There's no formula. It's statutory and gives every judge the discretion. We're going to talk about that. We want to try to give you some tips, whether you're in the middle of a divorce, whether you're post-divorce, whatever it may be. We'll try to kind of educate you a bit so that you can have an informed conversation with an attorney that practices exclusively in family law, just like we do here at Cordell & Cordell. We're around the country. You should go to CordellCordell.com. We have offices likely anywhere near you. You can schedule a consultation. That is really the only way to get good, solid legal advice by calling 866-DADS-LAW or going to the web, CordellCordell.com. All right, Robert, let's talk about it. Let's just jump right into spousal support. It's called alimony, maintenance, whatever it is. There's all kinds of terms for it, but it's really supporting a spouse. The first question we really want to know, if there's already a divorce or some order that's critical to determining whether you can modify, is modifiable or non-modifiable. Let's break it down, because I see, and I know you and I talked off camera, I see a lot of clients that come in and they come in with an order that we just can't do anything about because it depends on how your language is written in the decree, right?
Absolutely. So while the topic of this seminar is modification, it really starts beforehand. And it starts with the final documents from your divorce or negotiated dissolution or whatever it would be in your particular state. Ultimately, there are two types of modification award or spousal support awards. Simply put, modifiable and non-modifiable. At least in the state of Ohio, and I would imagine most states, the longer your marriage goes on, the more likely the court is going to issue an open-ended or a modifiable spousal support obligation. Many people, at least in our state, call it a lifetime award. And candidly, I don't particularly like that vernacular because it puts a bad thought into the payor's mind. Lifetime just means that the court retains jurisdiction in order to review it in the future. And many times that's to benefit to the payor. If you were to be locked into a 10-year period of support for X amount of dollars per month, that's a frightening prospect. 10 years is a long time. Imagine what your life or our world looked like 10 years ago, even 3 years ago. Things have drastically changed. And to lock yourself into a period of time as long as 8, 10, 12 years where the court cannot review it puts a lot of risk and onus upon the payer in order to maintain at least the same amount of income. Now, when we're talking about shorter marriages, there are many individuals who will look to locking in a rate for a period of time. This really goes to the amount of risk an individual wants to bear. Some of my clients will bet on themselves, i.e., I believe that the ceiling in my career is higher than it is now. I believe my income will go up. I don't necessarily believe that my wife or spouse will have the earning capacity to increase substantially. So I am willing to take a locked-in spousal support for a period of time, knowing that I will be able to make it up as time goes on. It really has to do with whether or not you're risk averse or not. In scenarios where clients have a capped ceiling, a lot of people will say, this is pretty much the height of my profession. I'm not going to get an increase in pay with any substantial amount. And therefore, I really need to be concerned about losing my job, God forbid, becoming injured in a way that prevents you from working. So I need to keep the modifiability open. At the end of the day, it really amounts to what each individual feels is right for them. But I can tell you that in really long-term marriages, 25, 30, 40 years, the idea of having a lifetime award is not something that necessarily should be feared, because the protections are in place for both parties, so that if something happens in year 3, 5, or 7, you have the ability to go to court and say, the circumstances have changed. This is no longer a fair and equitable award, and it needs to be modified. And so the short answer to all of this is, when you look at your individual circumstances, the length of your marriage, your particular career, those are the factors that are important in determining whether you want to consider a closed period or an open period.
Yeah, I think, you're right. Lifetime is a word I've used before. It's simply because in the state of Missouri, it is very difficult to modify or terminate. It's easier to modify, and necessarily terminate becomes a much more taller task. and it's very fact specific. And I think why this is a really, to start here, I think as you alluded to, there are people watching now that haven't yet have an order. So it really determines what you choose and what you negotiate, because there are ways to negotiate and settle, whether you choose an open-ended, where you can modify something down the road, or a closed end. And everyone is different. Their circumstances are different. That's what makes family law unique. You may be married the same, age is the same, but perhaps your job is different. As you suggest, your ceiling is different. And I think you have to entertain that. You may have other assets in which to negotiate away prior to. But I think as we talk about the modification, and there are some states, I think we'll talk with Mysti here shortly, but like Kansas, I know has a very specific formula about a max of 121 months of spousal support, I believe, or about 10 years or so. And then Texas, I think, has a more of a guide in terms of that. But Missouri is wide open. You will have the same facts presented to two different judges, and you may get two different results. And that's what makes it maybe a little bit frustrating for guys when they're faced with alimony maintenance or spousal support. But when we look to that, and that's the first step is, I'll meet with them, and I can tell you a lot of guys come in, maybe they didn't understand at the time that they either settled their case or the divorce decree was issued, what non-modifiable meant. And their situation, like COVID happened, unemployment went through the roof, people lost their jobs. How am I still supposed to pay this amount? And it's a non-modifiable defined term, say 8 years, and I don't have answers. And there's nothing you can do to modify it once you close the door. So that really is the first step when we talk about support. We'll get to what factors here affect it. But as you suggest, Robert, I think it's important. Shorter marriages, you tend to see more the non-modifiable, I think you said?
Yeah, absolutely. Just based on the fact that there's still a lot of runway time in terms of career. Also, although maybe not specifically on the topic of modification, it's important to note that people can buy out of spousal support in the sense that you can come up with a sum of money to provide to the other side, usually at a reduced rate, because obviously you're bearing all the risk at that point. She's gotten her money up front. There's no modification or termination necessary. So that's another thing that in relatively short marriages is widely considered, at least in my jurisdiction.
Yeah, I think it's key. And that you and I talked about terms that you hear, every lawyer uses maybe different terms. I use terms that confuse you, decretal and contractual. It's just something that you may hear. I think here's the key. We don't have to get technical about those terms, but if you're watching, go get, and you're divorced and you have a child support and you have spousal support, either or both, go get your decree right now. Let's start reading through it and see what words are in there. You're looking for non-modifiable or modifiable. Child support, and we'll get to, is always modifiable. You can't limit it other than by age of emancipation. We'll talk about that shortly. But age matters, retirement matters, especially people getting to an age where they want to stop working. So thanks, Robert. Mysti, let's as we set the stage of, hey, is it modifiable? Isn't it modifiable? What is it? Let's talk about the standard. And I know you're licensed in Texas, and so you can talk a little bit about Texas, and I'll chime in some things. And if others have thoughts on the modifiability and what the standards are, let's talk about it. But generally speaking, whether you're talking about child support or even spousal support, what's the standard that guys need to know in order to modify?
So in order to modify child support or spousal support, the first thing you have to do is show that there has been some kind of material and substantial change in circumstance. And that's such a vague word. A lot of times people say, well, what is a material and substantial change in circumstance? It really depends on the situation. The simplest answer to that is, has there been a change in the family structure? Has there been a change in your income, which would warrant either an increase or a decrease in the amount of the support? A change could be as simple as having another child, and now you have less resources to spread around, or you have more mouths to feed. A change could be you've moved out of town and now you have a greater distance with regards to visitation. Most significantly, though, the change is going to be loss of employment. Someone has lost their job or has had to change jobs and has had some kind of substantial decrease in support. There's also the circumstance where someone has gotten a new job and they have a substantial increase in support. So substantial change in circumstance, though the term may seem very vague, the bottom line is, has something changed in such a way that your ability to pay the support is different?
Yeah, and let me ask you, in Texas, and just so I can, for example, in Missouri and child support, if I can show an increase or decrease in income by 20%, it's automatically a change in circumstance. Do you have such a thing in Texas?
Absolutely, with regards to the child support.
Mm-hmm.
Not so much with regards to spousal support. So spousal support in Texas, and we call it here spousal maintenance, we call it statutory. So it is statutory maintenance here in the state of Texas. And there's guidelines that you have to meet in order to be able to get spousal maintenance. The first and most significant is you have to have been married for at least 10 years. And so in Texas, if you've been married for less than 10 years, you don't automatically qualify for spousal maintenance unless there's been some disability or some family violence. So there are a couple of other factors that the court will take into consideration.
Wow.
So that's kind of the starting point. But there's so many factors that the court takes into consideration when they're setting child support. And so when you're modifying child support, the court will not only look at whether or not there's been a substantial change in circumstance, but they go back to those original factors that they looked at in determining whether or not the person qualifies for spousal maintenance and what that number should be. The cap in Texas is 20% of your monthly gross income up to the first $5,000. So that's a cap. Spousal maintenance can be $250 up to, $4,500. It really just depends on all of the circumstances in setting an actual amount of support. And so you go back to that when you're looking at modifying. Has there been a change in circumstance? And now let's go back to the statutory factors to see how that's going to play in and where this number should fall.
It's so interesting, states like Texas and Kansas, I know particularly, and I'm listening, and I wish Missouri had such a structure, where you talk about a minimum of 10, and we're always spitballing, and a client comes in, has been married for 3, and we may say, well, not likely, but it's possible still. There's no minimum threshold here in Missouri. I mean, obviously a year or less, you're not likely. County by county, I can tell you, judges won't do this, they won't do that, but there's such wide discretion. And I'm sure there is in many other states with guys watching now, that it doesn't give a lot of guidance. But I love the idea, if you're in Texas or Kansas, you really have a much better idea of what to expect. But in terms of modification, I can tell you the hot topics that come in, at least in Missouri, and I tried a case for on this issue to give you an example, and I want to hear your thoughts on it, this was a classic example. 6-year marriage. The client was a doctor, makes good money, didn't see a decrease in income, but he's been paying for 12 years. So double the length of the marriage, he's still been paying a significant amount of money. Wife or ex-wife has done nothing over that period of 12 years to improve themselves, meaning more education, retraining, go getting a job, received around, $1 million in assets. We're 12 years down the road. The ex-spouse has no money left, has blown through it. And so we moved to modify on the basis of there is a continuing obligation here, at least in Missouri, to go do something to try to meet your needs and expenses. And what's interesting is, and the judge described this, is that the payment by our client, and he used these words, it's like a pimple on an elephant. It means nothing to an elephant. I mean, that he could afford it. So it really wasn't about his ability to pay. So that's one factor as we talk about is guy's ability to pay in the future. So it's really about obligations to become further educated, better employed. So do you have that in Texas, and what are you seeing?
So I will tell you that the responsibility of the recipient to show that they are attempting to earn income only comes in with the initial award. Once the award is granted, they don't have an ongoing obligation to show the court that, hey, I'm trying to find work, I'm trying to meet my minimum reasonable needs. What's interesting though is in Texas, we do have limits in regards to how long the spousal support will last. And so if someone has been married between 10 years and 20 years, spousal support will only go a maximum of 5 years. If you've been married between 20 years and 30 years, it'll go maximum 7 years. There are a few situations where we have what you termed lifetime spousal support, but that's only if the recipient is disabled and the disability occurred during the marriage. And so in that situation, that person will never have the ability to go out and earn enough income to meet their minimum reasonable needs. And so I keep using this phrase, minimum reasonable needs, because that's a key phrase here, right? The recipient, in order to qualify for spousal maintenance, not only has to have been married for 10 years, but they have to show that they are incapable of meeting their minimum reasonable needs. That does not mean going to get your hair done and your nails done and driving a Range Rover and living in a fancy house. That's not what that means. However, lifestyle is definitely taken into consideration. Yeah. But once you are awarded the spousal maintenance, there is no responsibility on the recipient to prove to the court that they are out trying to find work or trying to earn income. It's going to end when it ends. It's just not going to keep going even if you're not working.
I know there's 75 guys right now thinking, I wish I lived in the state of Texas, because Missouri is not like that. I mean, I've had clients paying for 25 years. And it was a short-term marriage, 6, 7, 8 years. And it is very case specific. And what matters is their ability to go do it. And I've tried so many cases where we can show that the spouse has an education, has training, but hasn't done anything, instead is going to Jamaica and to Cancun and, cigarettes and Cadillacs and living the high life. And it's crazy. And so I wish, a lot of those states, I wish there was a national standard, obviously, that'd make guys' lives easier. That's just huge. And that's, you and I talked off camera too, why divorce incomes are relevant today. And they may not be so relevant in Texas, but they are in Missouri. And you can kind of comment about what is in your divorce decree, and does it matter in Texas?
Well, it matters and it doesn't matter. Typically, when you have a divorce decree and you're only referencing spousal maintenance and there's no child-related issues, you're not going to find the income information in the decree. You won't know what the person made. Again, because there's so many factors that the court takes into consideration in setting spousal support, the income alone is not the only factor. That's your starting point. And then we look at how much money does the recipient receive? Does the recipient receive child support? Does the recipient have separate property? How much property was the recipient awarded as part of the divorce? What are their capability of making income in the future? Are they going to get any inheritance? So there's so many different factors that the court takes into consideration when they're actually calculating spousal support, that the income alone is not as significant. So you won't really see that, or you won't see that in a decree where you're only referencing spousal maintenance. Definitely with regards to child support, it's taken into consideration because child support here is a very hard and fast formula, right? Yep. They don't care about anything except for the income, right? And then the percentage. And so that kind of formula you'll see in your decree, but spousal maintenance you won't. So, it's a little harder to modify because you really have to prove, what were the circumstances at the time that the original order was entered into, and what are the circumstances now, and how did they change? And because you don't have that information in the decree that says, hey, this formula is based on A, B, and C, it does make it a little more difficult when you're looking to modify those numbers.
As we kind of round out the topic on maintenance, a big one, and I just had a client ask this question. His ex-wife is cohabitating, has a boyfriend, they're engaged, but they haven't married. Does it matter?
It matters in the state of Texas. In Texas, there are 3 circumstances in which spousal support will end even prior to the end date, because we always put an end date in the decree unless it's a disability. One is remarriage, one is cohabitation, the other is death. And so if you can prove that the recipient is cohabitating with someone of the opposite sex, then that is a basis for you to get your support modified. But make sure you have the facts. Make
Yeah.
sure you have the evidence and you can prove it, because, you know, that's one of those things where it's like, he may spend the night once in a while, but he doesn't really live here. So it's important when you're trying to terminate your spousal support early, right, that you have the evidence to prove that that is the circumstances.
That is so key and critical. I advise this client to start gathering some evidence before we proceed, to make sure that, you know, when you open that can of worms, we can prove it and we're not wasting our money. And it is a big factor in Missouri to some extent. It's kind of a pseudo marriage. You see the statistics nationally, probably worldwide. The percent and number of marriages is declining, but the percent of individuals living together is increasing. And so you're seeing the kind of, not the formality of a marriage, but it's the informality. They're living together, like what you had referred to, or we have referred to. I talked about it in a podcast as common law marriage. It may not be officially recognized, but that's what the courts are kind of looking at, and who's contributing to the expenses, and they're using it as a retirement. It's a fascinating area to inquire and termination, because judges pay attention to it. I think it's interesting. And without getting into the retirement part as an element of modification, because there's some questions, we'll save that for the live questions, and I'll come back to you on that, Mysti, and because I know there's some questions about, I'm thinking about retiring, I want to retire, how does that affect, when can I do it? So we'll save that, and we'll just go right on to child support. Thanks, Mysti. All right, Kellan, we alluded to it, that kind of that magical number of 15%, 20%. There's people like, how do I modify my child support? What is the magic number? What are the standards? So Kellan, tell us a little bit about that, and at least from the Tennessee's perspective, and I'll chime in as well for Missouri.
Absolutely, Scott. So when you talk about child support, the thing to understand, of course, is that every state can be truly different, as we're seeing here on this podcast, this webcast today. For example, Tennessee seems to be very similar to Missouri, but not so much to Texas. Now in Tennessee, that magic number is 15%. The term Tennessee uses is a variance. So if your child support obligation will vary up or down 15% or more due to the change in circumstances, then you can modify it. Now, until very recently, Tennessee also had an additional requirement, which was this change in circumstances, very similar to what you heard Mysti talking about. Just last year, Tennessee removed that requirement. So the only necessary step you must clear is that 15% variance. And all that simply means is that if what you are proposing the new child support should be, if it is 15% higher or lower than what it was set at your divorce or from the last time it was modified, then the court says you can come to court and seek modification. Now, of course, you have to prove it. You have to prove what that variance would be. Now, sometimes, as Mysti mentioned, it can become a numbers game. It's a very strict formula. Tennessee uses, we call it a child support worksheet. I'm sure a lot of states have very similar documents that kind of does the math for you. And the two magic numbers that you put into this document are the amount a person makes, each parent makes, and the amount of days they have with the child. And that's how it works in Tennessee. And that worksheet will spit out what your obligation is. Now, when you talk about modifying, the thing to keep in mind is your state may be a little different. So in Tennessee, for example, as I mentioned, we only got to prove that 15% variance. In some states, it may be 20, it may be a different number, and you also may have to prove a change in circumstances. And now changes in circumstances, depending on your state, can involve may look in a myriad of ways. So for example, maybe some of the children that the child support order is covering have aged out. The term you will frequently hear is emancipated. So in Tennessee, what that means is a child has turned 18 and they have graduated high school, whichever occurs later. So let's say your child turns 18 in February, they graduate in May. That's when we graduate here in Tennessee. Your child support obligation would not stop until May. However, if they were to graduate in May and turn 18 in August, it wouldn't stop until August. So just keep that in mind as you look at your child support order, and also keeping in mind what your state may do, because this is kind of important. In Tennessee, for at least, your child support will not stop automatically. Maybe the number one question I get about child support or issues that come up is a father thinks, okay, my child has emancipated, they've turned 18, they've graduated high school, whatever other step or age of their state may dictate. I know some states can go up to 21. and they think, great, I'm done. In Tennessee, it doesn't stop. You have to take action to actually stop or modify that child support.
Interesting, because, as you mentioned, Missouri, you could be paying child support through college, but it's on the upon emancipation. You really don't have to take action unless they continue to take it out of your check or you're making the payments. I find that interesting. What comes into play is, for example, you have someone graduate high school, they're 18, they're going to college. Do you keep paying? What amount do you pay? Are you paying for room and board already? So are you double dipping? It creates a whole new set of issues to approach. And it's not impossible, because certainly there is a way to either suspend payments while you're paying room and board while they're living away. So I think that's a whole nother conversation we could probably spend a whole hour on talking about, outside of Tennessee. But one thing that I think that is really popular in terms of modification is you have more time that's called for in the parenting plan. You have more overnights. The other spouse is just saying, okay, I'm going to give you 80% of the time and you were only supposed to get 30%. Is that a reason or good point to modify?
Absolutely, Scott. And we see that a lot. What I like to tell people is a parenting plan gets set at the divorce, and it spells out, we call it a parenting plan, by the way. Some states may call it a custody plan, something along those lines. And it spells out how much time you have with your children, how many days a year, or, what days. What we frequently see, of course, is that life happens, right? One parent or the other will start offering more time. And so, with our clients, you may get a client who starts to have the child more. I have a case where the father was only supposed to get every other weekend. He ended up having 80% of the time. And so we sought to modify, of course, the child support, but also the parenting plan for us, because it wasn't accurately reflecting what the parties were doing. But that definitely will alter child support. The reason is, as I mentioned when I started talking, was that child support number is derivative of your pay and the amount of time you have with your children. Mm-hmm. So if suddenly you go from having 80 days a year to 200 days a year, then that's going to shift. Now, in Tennessee, we use a term called the primary residential parent. A lot of people get hung up on this term. All it simply means, in Tennessee at least, is that you spend at least 50% plus with your child a year. So as long as you have over 50%, you are the primary residential parent. You might hear it called the PRP. But that usually means the child support is going to shift from one parent to the other, or if there isn't a shift of who the primary is, it's at least going to affect the numbers of what the actual obligation is. So that's a really good example that you might have to modify your child support. Now, of course, the other one, due to the pandemic, as we have seen, could be a change in your pay, or a change in your ex-spouse's pay or your current spouse's pay, which is big. If the pay changes, the child support can change. Now in Tennessee, as I mentioned, we're only looking at that bottom line number. Is there a 15% variance or not? In other states, however, you may have to meet this additional hurdle of the change of circumstance. But I do think you kind of see it go hand in hand. If something's going to change child support 15% or more, then it's usually going to be something has happened to cause that change, such as a change in parenting time, as you mentioned, Scott.
Right. So one thing is we have a lot of questions. I want to get to those. So we're going to just go to our lightning round here shortly. And then the last question, and I think is a word of caution for many when it comes to child support modification, is they get along really well with their ex-spouse and they decide to orally modify their child support. And they, it's, hey, I'm going through a rough time. I was laid off, it's COVID. Can we just agree, instead of paying $500, I'm going to pay you $100? And she says, sure, no problem. That's a problem here in Missouri. Is it a problem in Tennessee?
Absolutely. You need to follow the order as it stands as best you can. Now, obviously, in situations like Scott mentioned, it sure could be easy to say, hey, she agreed. I'm going to pay less. But a court's not going to look at that. Court most of the time is going to go back to that original order and say, sir, you're told to pay $500. You now have an arrearage. That terrible word that no one wants to hear, but it just means you owe back child support. And because you weren't paying the amount the order said.
Yeah. I mean, I think I can tell you, I've had people who had the best intentions, or at least our client did. And he said, but she told me and she took my payments and I've been paying that for 5 years. And all of a sudden now they have a dispute. A lawyer tells her, well, you can go get the 5 years of, the difference. And they're right. they can go back and hold them in contempt and put them in jail. And so you have to just be cautious. I think when we talk about modification of child support, it has to be by court order. Whatever, if you guys agree, then just file the order. Judge has got to sign off on it. So I know we've got a lot of questions, and I want to make sure we get to all of them. So let's just go ahead and we'll address still all of the issues that we have on child support and maintenance, and we'll just answer them through these questions. So let's get to the lightning round. So thanks, Kellan. Let's just get right to it. So I'll just stay with you, Kellan. Ed in California says, I have a 30-year-old spousal support obligation, alimony. I'm now 72, hoping to retire, but I can't unless I can reduce or eliminate the spousal support payments that are currently $5,000 a month. So let's talk a little bit about Tennessee, obviously, since we don't have a California, one of our California lawyers on the line, which Ed obviously would encourage you to, we have plenty of offices throughout California to seek a consultation. But Kellan, Tennessee, what does Ed do? 72, clearly at retirement age. What is kind of he should be thinking about?
Sure, absolutely. As you mentioned before, Scott, I think the number one thing Ed should do is get that paperwork and see what it says. Find out if those terms that we were using earlier, modifiable, non-modifiable, what kind of spousal support was ordered to determine if it can be modified or not. Now, as Mysti mentioned, in Texas, Tennessee has a very similar idea, which has there been a change in circumstances for modifying alimony? We call it alimony. Some, a lot of states call it spousal support or maintenance. The question becomes, once again, why are we seeking to modify? What has happened? What has changed? When it comes to retirement age, a lot of times what we deal with here in Tennessee, if the alimony is modifiable, is we make that very argument. We start looking at what is the income going to revert to. Are you going to be living on Social Security, or do you have a retirement, a pension, whatever the case may be? And that gives you those grounds. The change of income will be severe, it sounds like.
Yeah, and I think, Ed, I'd encourage you to start the process now, because obviously with COVID, everything seems to have slowed down. Now what used to take 6 to 8 months in Missouri is probably a year to 2. So you want to get into court, start that process, because you can always look to either terminate it retroactively if California allows that. So it's to the date of filing or service. I encourage you to set a consultation, just review it. And they're going to look at maybe pensions, 401k, IRAs, what your income will be, what her income will be. She'll be drawing off your Social Security, which you probably already now. You may have postponed it. That's all a factor. So proactive, jump on that. All right, Robert, this is coming from Bill in New Jersey. I'm thinking about changing careers. How will that play out prior to or after the child and spousal support is assigned? I'll need to change careers to allow more time with my kids. Is that going to be basically used against Bill, or what should be Bill thinking about?
Yeah, so I mean, the short answer is the other side is obviously going to try and use it against you. I mean, that's the reality of the situation. The argument will be that this is somehow intentional on your part to circumvent or minimize any obligation. With that being said, if this is a plausible change in career, i.e. if you were a CEO of a company and now you're deciding you just want to work in fast food, they're not going to accept that. Okay, there has to be a logical sort of transition between one to the other for the court to accept it. And candidly, a factor they will consider is flexibility in schedule in order to spend time with the children. On a similar sort of situation, individuals who are married, I work a lot of overtime because, well, we're all in the same household. I have childcare, i.e. my spouse is there. All of a sudden, they're using my overtime against me. Happens all the time in Ohio. And we have to make the argument, and it is held against them by the other side. But our argument is always, I was doing that overtime to better support my family while I knew that they were being cared for at home. Whereas now, I'm getting half the time, or I'm seeking half the time. In order for me to actually be able to do that, I need to cut back on overtime. And as a result, it shouldn't be considered. So it really depends on the facts and circumstances of what you're trying to do and whether or not it ultimately looks like you're trying to benefit the familial unit, or whether they would accept it or not.
Yeah, I do think it's case specific. I've had cases where we've been successful in allowing a change based upon what's going on. And I think you're right. So encourage them again, get a consultation. It's the best hour you'll ever spend. All right, Mysti, next question. This person's daughter is 21, a full-time college student, living off campus and paying her own rent. However, his ex still receives child support for the daughter. The question becomes, is the daughter emancipated? Obviously depends on the state. What does Texas say?
Well, in the state of Texas, child support ends when the child turns 18 or graduates from high school. And so Texas doesn't have laws which require someone to pay child support once the child is in college, unless they're paying arrears, right? And so I think I remember someone bringing up an issue of arrears. Arrears payments will continue until the arrears are paid in full. So we have often people come in and they say, hey, my kid is 28 years old and I'm still making payments towards child support. And then we go and we look and we see that they're actually making payments towards arrears. Arrears will continue until paid in full, or unless the parties otherwise agree to do something different. But here in Texas, you won't have the situation where you have a child in college and you're still paying child support, because it would have ended unless the parties contractually agreed to do something otherwise, in which case it wouldn't be modifiable. You have to follow the terms of your contract.
Yeah. In Missouri, it does go till college. And I think that was what I was alluding to. I think Kellan and I were maybe talking about it, was you actually have to be proactive. And these facts, the question becomes is why the daughter is paying the rent on her own. Is she working and supplementing? There's certainly an argument, and I've been successful in our state in saying that while the child's away, if the child's working, there is no child support paid to the ex because they're not needing that much money. Now, there may be a nominal amount, depends on if the child intends to come back. Has a child returned in the summer months to live with mom? If the child hasn't, then there's even more justification to say child support should be suspended until emancipation. Now, in your state, emancipation may be 18, it may be 20, it may be 21, it may be 22. Have a consultation, figure out what the age of emancipation is, and clearly whether or not you should be seeking to modify. All right, next question. Kellan, how serious does, for example, Tennessee family courts take violation of custody? This person, they have a 50-50 agreement, but they haven't seen their child in about a month. The mom is alienating the child, parental alienation. They live in Pennsylvania. They filed for contempt, but it's not going to be heard for another, say, 2 weeks.
Courts in Tennessee do take it fairly seriously, and depending on the circumstances, it could even progress into something more serious than just contempt. What we have seen sometimes, due to the mobility of our society now, it's all too easy to cross state lines, and then it becomes very difficult for the parent who should have custody to get the child back. Now, for example, Chattanooga, Tennessee is right on the border of Georgia. Like, I think I can see it from my window even. That doesn't necessarily mean if they, cross over to get a milkshake that they're violating state line laws. But what we do see happening is when custody plans are violated, normally you do file a contempt motion, as it sounds like it's been happening there in Pennsylvania for that viewer. Courts take it seriously because, in effect, you're not only violating a court order, which, of course, no judge is going to like that, but you're also taking time away from someone else. They can't get it back. Once that time's gone, it's gone. And what we will frequently use, violations of a parenting plan or a custody plan, as reason to modify the plan if the other parent or client is seeking more time, because it shows that the other parent can't follow the order. So it is a pretty serious event.
Yep, agreed. All right, Robert, here's a kind of a follow-up question, similar child in college. In regards to New York state law, which obviously not one of our attorneys is on in New York, but let's just talk about Ohio. This person, Dave's child, had a full scholarship to a New York State college and chose to go to an out-of-state on a scholarship at a lower amount, it appears. Dave wants to know, obviously, should they continue to be paying child support if they now live on campus in an entirely different state, and maybe just interested what Ohio does with that.
Yeah, so it leads me to first believe that I'm really happy that my clients are residing in Ohio, because it appears many other states have more rigorous or lengthy child support obligations. Similar to Texas, in Ohio, your obligation is going to end either at 18, at graduation, but no later than 19. So that means if they were 19 and still in high school, it would end at 19. We're one of the handful of states that will also allow certain circumstances in which the child is disabled for it to continue indefinitely. But certainly in the state of Ohio, the idea of paying during college is not something that is going to happen. And candidly, the inverse is true. If we're talking about spousal support and modification, one of the factors that the state of Ohio can consider is paying post-secondary education as a reason for a modification or a deviation in support. So that could be used to your benefit in the state of Ohio if you were the one actually paying for the schooling. But certainly here, it wouldn't be an issue about continuing payment while in college.
All right. All right, we still got a lot of questions coming in, so let's do these in 30-second increments if we can. Mysti, if I've divorced in one state but been moved to another, can I modify support in my new resident state?
It depends is the easiest question. If we're talking about modifying spousal support or modifying child support, if you're modifying child support, you need to modify child support in the state that the child lives in. If you're modifying spousal support, then you always go back to the court that entered the original order. And so you would have to go back to the state that entered your order for your spousal maintenance or spousal support.
Kellan, my ex is grossly undercompensated for her level of education. Her parents are paying her mortgage, give annual gifts of cash, and recently purchased a new car. Can I challenge the income?
Absolutely. Whether you're talking about child support or alimony, at least in Tennessee, and I'm sure in a lot of other states, you can challenge the income that they put forward. The best way to do that is through discovery, or where we get information as lawyers, to start looking at bank accounts, looking at charge accounts, credit cards, things of that nature. That's going to be a more true reflective amount of income. And courts are receptive because it's all too easy to underreport income. So I think absolutely it is something that should be pursued.
Yep. All right, let's go, Robert. I have a final orders hearing on September 8th. I know that the opposing party will be getting a $8,000 increase in January 2022 in their salary. This person's salary increase will be far less. Can the final orders include an automatic review in 5 months without re-engaging lawyers from scratch?
Sure. I mean, I wouldn't necessarily call it an automatic review. I will simply say that hopefully your counsel has done their due diligence and has documentation evidencing that the raise is in fact going to take place, at which point nothing precludes a court or an agreement that says you will be paying X dollars until specific date, upon which it will change to Y dollars for another period of time. So not only can it include a review, but it can actually just have the number and have it change automatically.
Yep. All right, Mysti, Simon wants to know how government aid affects child support calculations. This is in the state of Virginia, but in terms of whether it's COVID money, other benefits and aid, does that get factored in terms of income in the state of Texas, for example?
So it doesn't get factored in with regards to the calculation of child support. So if someone is receiving government assistance, TANF is what we call it here, or food stamps, something like that, that's not considered in the calculation of child support. If someone's receiving those type of benefits, then they're likely making a minimum wage. And so child support would be based on a minimum wage. So it's not likely to be considered. COVID money, that's a little different, right? Are we talking about loans? Are we talking about stimulus? If it's stimulus checks, probably not, right? Because that's part of your taxes. So it really depends on the source of it. But I will tell you in Texas, the state considers all sources of income. They will not consider government assistance though.
Just staying with you since this question's on Texas child support. If the primary parent makes more or equal income, how is child support, or how is that factored in child support in Texas?
It's really not. Texas calculates child support on a percentage guidelines of the payor. We do not take into consideration the income of the recipient spouse or the recipient of the support. It's just going to be a straight percentage, 20, 25, 30%, just depending on the number of children of the payor's income.
All right, Kellan, if my income, Nathan wants to know if my income drops substantially, can Nathan drop support, whether it's child support or maintenance?
So it is a reason to seek a modification, but you got to be careful. You can't do it on your own. You have to get a court approval to do it. So if you're seeking to modify child support, if you're seeking to modify alimony, if it's modifiable in your state, in your situation, You have to seek court approval by filing something with the court. You can never stop on your own. That'll get you into arrearage territory or child support, contempt issues with alimony. So be very careful there. That's why it's, as Scott mentioned, it's good to act proactively. If you know something's going to happen, that's going to change your situation, start looking at taking that action now.
Yep. All right, Robert. Raul has a question regarding change of income. Switched companies and taken a significant pay cut. I assume the circumstances of my switching companies will factor in if a possible reduction of spousal maintenance.
Yeah, absolutely. This actually is a perfect follow-up question to one of the previous answers I had about transitioning to a new job. The facts and circumstances about that transition are going to be a major factor, at least in the state of Ohio. If you find yourself having lost a job and in a new job due to your own fault, so to speak, then the court has the authority to impute your income or maintain you at a particular income level because you have lost that job. Now, if you had lost your job and found a new one, and you can show the court, I've done everything in my power in order to try and retain that previous income level, I think you're going to be pretty well okay in getting that modification. So long as, again, you haven't lost your job due to your own fault or negligence, and that you've made substantial efforts in order to try to find an income at the same or similar level.
All right, Mysti, John from Texas wants to know if she remarries when it comes to spousal support, is she still entitled to it? Also, if she's highly educated with a successful career, is spousal support likely for her to obtain?
That was two questions. So if you remarry, then the spousal support will end. It ends on remarriage or cohabitation, as I mentioned earlier. If you have a successful career and you are earning enough income to take care of yourself, then the court is not likely to order spousal support initially. Again, in order to be able to qualify for spousal maintenance, you have to show the court that you're incapable of meeting your minimum reasonable needs. If you are capable, then it won't be ordered. If spousal support has already been ordered and then you go out and you get a great job and now you're making as much as the payor, then that is a basis for the payor to go into court and ask the court to modify the support because you are now capable of meeting your minimal needs and it's not necessary.
Staying with you, Mysti, Texas question, can military spousal support get modified?
Yes.
Easy enough. All right, let's go to Kellan. My spouse has filed to get alimony from me until one day before my 70th birthday. I'm planning to retire in 4 to 5 years at age 65. Tennessee, and kind of just go through and just seek all the way until 70, open-ended. What is the kind of policy on spousal support?
Spousal support in Tennessee is very similar to sounds like Missouri, Scott. It's completely open to the court's decision, right? It's statutory in nature. There is no set way to calculate it. There is no set percentages, timeline, or anything. It's all dependent upon the specific facts and circumstances of each case. We do have this come up a lot where someone that might be nearing retirement age, and the question becomes, well, do we do alimony? In Tennessee, there can be alimony that goes, we call it in futuro, it just goes until someone passes away or remarries, or there can be shorter ones, just like the other attorneys were mentioning earlier, but it is completely dependent upon the facts in the state of Tennessee. Of course, it may be different in your state, so it's always good to get a consultation in your own state to make sure that you're getting, whether it's modifiable, not, whether it stops or doesn't, things of that nature.
Robert, Ohio, can a spouse refuse to look for a good job when they have a 4-year degree? Or can they just look for the lowest paying possible job and still maintain maintenance?
Yeah, obviously, if there was a hard and fast rule, we would be obsolete. So candidly, and just recently, I had a case, frankly, yesterday, in which we had to invoke a vocational expert, an individual who comes in and assesses the person's age, education, and work experience and determines whether there are jobs and income within the regional economy to determine what they should be earning. And so while we can do that, no court can force an individual to work at a particular job. The best the court can do is impute a particular income based on that degree and determine support, if any, based on those numbers.
Yep. Mysti, on spousal support, this is out of North Carolina, but is retirement, you can mention on Texas, is retirement income considered in modifications of any type of spousal support?
Well, it is. So if, let's say someone was working full time and they are now retired and they're just receiving either pension payments or maybe distributions from a 401k, it's still income. And so any income they receive, the court can take into consideration in regards to the calculation of the support. Now, if someone was earning, $300,000 a year, now they're retired and now they're living off of $2,500 a month, that's certainly a basis for modification. It's certainly a basis for the court to review that information, and the support levels may go down. It may not be a basis for them to terminate the support just because someone has chosen to retire.
Okay. Kellan, the question, it's a two-part question. If you invest in the spouse, immigration, training, job during the marriage favorably, can it again be favorable to you in terms of spousal support termination? And then the second part is, after the divorce, how can you find out about changes in income? So first one is, if you do everything, pay for their school, their career, their immigration, their training, all of that, does that look favorably upon?
So I think it's going to look favorably upon the initial determination of support, maintenance, alimony, because the court at that point is going to make a decision as to whether the other spouse has received a benefit from the marriage is so much that maybe alimony shouldn't be continued or should be continued at a lower level. What I will say is, can it support a modification? It depends on the facts and how much we're talking about, but I think it's more pertinent to that initial determination. Now, the second question is how can you find out the income? A couple ways. First off, if you have children together and there's a child support order, in Tennessee at least, the parents have to supply proof of income every year. They have to swap out proof of income. What I will say is, if you don't have children, you need to find it another way. If you do have an attorney or you hire an attorney, we can do what's called discovery. It's a process where we seek information, and if we're allowed to get that information, such as pay, then we have to get it. They have to turn it over. And I think that's the most common way to get it once you're in the legal process.
Mysti, on custody, what is the recommended action if the other spouse refuses to abide by court order regarding custody or any other matters?
To hire an attorney and file an enforcement action. So the first step is to consult with an attorney, review your order, make sure that you are also following the order with regards to your periods of possession, when you're supposed to pick up, and the times that you should have the child. And if you are following the order and doing everything you should be doing and they are not, then you have a basis to file an enforcement action against them. The court can hold that person in contempt. They could put them in jail. They could order attorney's fees. They could sanction them. So you have a lot of teeth in these orders, but you have to make sure that you are following the terms of the order to the T.
Okay. Mysti, one follow-up. Texas is popular today. Is overtime part of child support calculation, or do I get to keep the overtime money?
Overtime is absolutely part of child support calculation. Every income, every number, every dollar that you earn in income, the court can take into consideration. They can also take into consideration what we call imputed income, cell phones, car allowances, clothing allowances, all of these other extras that an employer gives you. The court can take that into consideration in the calculation of your monthly child support.
Robert, Javier lost his six-figure income because of COVID. Wife filed for divorce in Florida. She makes similar amount of income, six figures at the time. Finding a similar job for Javier is proving very, very difficult. What do you recommend as she wants to get divorced quickly? It seems like Javier thinks that it's better for him when he's not working rather than replacing that income.
Yeah, well, it would never be my suggestion to refuse a good job if it's available to you. But under Javier's circumstances, depending on the length of the marriage, at least in Ohio, it is possible that the script has been reversed and that she will be the obligor to him, the obligee. And certainly that could be the case in Ohio. Again, similar, a perfect segue from my prior answer, assuming Javier can show that he's making the reasonable efforts in order to find similar or same income within that field, he's going to be fine. And that's why spousal support, at least in Ohio, exists in certain circumstances. We have a scenario where one spouse is now down on their luck. She wants the divorce. You're probably entitled to something.
Yep. All right, here's a question from Missouri. I'll take it, and then we'll get to like one or two more. We're running out of time. This is from Missouri. It says, I have a 5-year non-modifiable support payment. After 5 years, it drops down a bit. Can I modify it further or get it dismissed? It was a 20-year marriage. She currently does not work, but is a side business. So it is difficult. It really depends on what the language is in the decree. It sounds like, but I can't tell, that perhaps it was 5 years of non-modifiable maintenance, and then it drops to another figure and becomes modifiable thereafter. So I'd want to see that decree. We'd be happy to meet with you, whether it's in Kansas City, St. Louis, wherever here, or do a Zoom and look at that decree and make a determination. But obviously, they've got a side business. We did a podcast on side businesses, which is really popular, about finding cash and where that is. It's hugely popular, and it's a good way to start proving maintenance modifications or child support modifications. So let's try to find one more or two here real quickly. We've got a minute. Let's go to Kellan. My question is, the divorce is final. I'm on Social Security disability. My 2 sons are recovering more money now. Can I take her back to court and ask for reduction in my 1/3 medical expenses for the 2 sons? She makes a substantial amount of money. So it sounds like the children are getting more money. This person's on Social Security disability. Can I modify my child support?
Depending on your state, depending on if it's a number variance, as I mentioned before, 15%, or if it's a significant change of circumstances, or both, it sounds like you maybe could. The change in circumstances might be the income that your children are getting. But once again, it all depends on what that magic variance number is. Tennessee, it's 15, other states, it's 20. So it really depends on what your state says. But I think it's something you could look into by speaking to an attorney, just to see what your state's requirements are.
Okay. Robert, custodial parent, has primary custody. They enrolled 2 minor children in private school, which has a high tuition without input, consent, or agreement. Now they're asking me to contribute to that tuition. Can the court mandate that?
Yeah, so first, I think it's important that you understand what custody means in your particular state. In Ohio, if one parent is the custodial parent, they have the decision-making authority. So they presumably could enroll the child in to private school. Now, they can't necessarily demand from the other side the money, but they can certainly seek a modification. In Ohio, while tuition is not a factor that goes into our worksheet or our formula, it is a reason that the court could deviate. While most people consider deviations downward, it can also be a deviation upward. So she would have to petition the court in order to seek that upward deviation for contribution. But I think you probably have a good argument to say, I wasn't consulted, I probably wouldn't have agreed to this. And if she wants to do it, it's on her to financially support it.
Yep, great. Last question, unfortunately, for the day, because we're way out of time. Mysti, this relates to child support arrearage. The child was emancipated in 2013. However, there are arrears being paid for previous periods in which I was unemployed. Is there a way to vacate, reduce, or settle that balance in terms of just trying to figure out a way to negotiate it to get rid of it and be done with it?
Only by agreement. So if the recipient is agreeable to vacating or waiving the arrears, then the state will accept that, then the courts will accept that. But if there is not an agreement to do so, then unfortunately there's not.
Yeah, and I've had the situation where you're going to have to come up with some cash up front in order to have a chance of doing it. Sometimes the present need of a lot of money or some money up front will dispense with the remainder of that. And you've got to have an incentive in order to negotiate it down. Or perhaps they get nothing. That's the way that they're looking at. So it is certainly worth a conversation with an attorney. So, all right, thanks to the panel today. We are totally out of time. I appreciate it. And if you have questions, we've gone through a lot of this. We know that a consultation is the way to go. None of this considers really any of the specific facts of your case. We'd encourage you to find an attorney that practices exclusively in family law. We have offices around the country, and we have also referrals that we can get you to. So give us a call at 866-DADS-LAW. Go to the web at CordellCordell.com. And the questions we couldn't get to, we'll put on a podcast coming up. So go ahead and subscribe to the podcast. We'll get those questions answered in a podcast coming up. So go to Apple iTunes, subscribe. It's the Men's Divorce Podcast that we do twice every week. 10 minutes. Listen on your drive, listen at night. You're going to find a topic that's relevant to you before, during, and after divorce. We'll have another one of these virtual town halls next month. So check it out at cordellcordell.com. Until then, have a great week.